So is the will valid? In Michigan, a valid will must comply with a particular statute. It's MCL 700.2502. Here are the elements. The will is in writing. The will is signed by the person making it. We call that person the testator. Actually, if the will is not signed by the testator, it can be signed by another person in his or her name at the testator's direction. A lot of people don't realize that. The will must be witnessed by at least two persons within a reasonable time after witnessing of the will. Now, you may have heard something called a holographic will. A holographic will is valid in Michigan, whether it's witnessed or not, if it is dated and if the testator's signature and the document's material portions are in the testator's handwriting. We see this often with suicide notes and other handwritten documents. The key is that it's dated, materially in the handwriting of the testator, and signed by the individual. The requirements of two witnesses in a holographic will are just simply not needed. Now, there is something in Michigan called the substantial compliance rule, and the document or writing is treated as if it had been executed in compliance if the person advancing the will establishes by clear and convincing evidence that the decedent intended the document or writing to constitute any of the following: the decedent's will, a partial or complete revocation of a decedent's will, an addition or alteration to the decedent's will, or a partial or complete revival of a deceased's former will. So this substantial compliance rule is really helpful in situations in which the technical requirements of that statute that I referred to are not met. It doesn't cause the will to simply fail if you can prove by clear and convincing evidence under the substantial compliance rule that there was an intention to create the will. This happened quite often where the document would be perfectly created, but for example, the testator would sign in the witness spot and the witness in the testator spot, or maybe the witnessing failed for some particular purpose. So the idea is to allow the testator's intent to still control in circumstances where there's a technical failure complying with the court statute. Now, of course, with wills, there can be lots of fighting and disputes about whether a will is valid or not. And of course, when you're preparing a will, you want to do so with a skilled, competent probate practitioner to ensure that your wishes are carried out. The goal here is not to have a fight in the court. The goal is for your intentions to be carried out through the will. If you've got questions about probate-related issues, a will, or anything related to these topics, visit us at theprobatepro.com or call us at 1-833-PROBATE.